The broadcast is now starting. All attendees are in listen-only mode.
And good afternoon. I'm Marvin Schwartz. I'm the COO at American Chamber of Commerce Resources, as well as hrsimple. We'd like to welcome you all to today's webinar for investigating complaints in today's workplace. Just a little brief overview of how this will work. It's about 60 minutes long, so prepare to have some really good information. At the end of the webinar, I will provide SHRM and HRCI codes, and we'll put them up on the screen for you. If you have any questions, there's a question area in the chat box. Patrick, who will be presenting, says that when he gets to the end of each section in the webinar, he'll be willing to answer any questions that you guys have left during that segment of it, and I'll read them back to him and he'll answer them for you. And don't forget, you can go on youtube.com/hrsimple. Give it a couple days and this webinar will be there so that you can refer back to it if you want to. Our presenter today is Patrick Smith. He's a shareholder of Fredrikson Byron. They're out of the Des Moines, Iowa office. He represents public and private sector employees in a broad spectrum of employment and labor matters, both inside and outside of the courtroom. We're very happy to have him here. Of course, Fredrikson and Byron, they are the people that put together our model policies and forms for Iowa employers online manual. That's on our hrsimple.com website. So feel free to go to the product page and pass that out as well, or take a look at it at least and see what you think of it. At this time, I'm going to pass this over to Patrick, who will take you through today's webinar entitled Investigating Complaints in Today's Workplace. Give me 1 second here. And of course, every time you try to do something, it never works out the way you want it to work out. But now I think, oh, still looking for it. Sorry for the little technical difficulties here. Here we go. See, every time you try to make this work smoothly, it just doesn't happen. But I think we're there now. Patrick, I'm going to pass it over to you and you can take it from there.
Okay, very good. Hopefully you can see my screen here. Today's topic is investigating complaints in today's workplace. Marvin, thanks for that introduction, and good afternoon to everyone on the webinar. Our agenda today has 4 different topics, so it's a full agenda for our hour. They're on this slide here. We're going to talk about when and why should an employer investigate. That seems to be a very hot topic nowadays. And then when that decision is made to do an investigation, what should a company and an investigator do in the planning stages of it? Next, the execution stage, that is actually conducting the investigation. And then once that's over, what do you do then? Managing the outcomes after the investigation. As Marvin said, each section, the 4 different sections, will have a break between them in the slides. And if there are any questions about what I've been talking about, Marvin will tell me what those are and I'll do my best to answer them. And we certainly welcome questions about any of this content here. So let's get started first with investigations, when and why. This slide lists several situations that may trigger an investigation. And in today's environment, as I'm sure most of the viewers and listeners are aware, the hashtag #MeToo era has made companies much more sensitive to the need to investigate, perhaps more likely to investigate. So one trigger might be a legal obligation. You might get a charge from an agency like the EEOC or a state civil rights commission. It may not necessarily be a discrimination or harassment situation. There could be an accident in the workplace that warrants an investigation because of the OSHA laws. The company might become aware of potential misconduct by somebody, either by observing it or hearing about it, or because of a formal complaint to HR, or because of a union grievance. I mentioned already agency contact. That could be you get a complaint from the EEOC, or perhaps the Department of Labor contacts you and wants to do an audit. Contact from a lawyer is a very common thing that might trigger an investigation. One of your employees or former employees may have retained counsel, and that lawyer sends a demand letter saying they're going to file a claim, and you've never heard anything about it. So you need to investigate to find out what to do next. Some of the sources of complaints that may trigger an investigation, traditional forms would be complaints pursuant to the company's complaint policy or harassment policy, written form, email, verbal. Nowadays, companies are becoming more sensitive, as they should be, to less formal means of information about misconduct or harassment. In the old days, it was more common for companies to take the approach that, well, if I get a complaint from the employee that they're being sexually harassed, then I'll act on it, but otherwise I don't know. Now that's not really a good approach. If other people see something, whether it's a supervisor, a fellow employee, or a third party, and that information comes to management or human resources, that's something that probably should be acted on. Exit interviews is a not uncommon source of information about misconduct that may trigger an investigation. Could be the employee is leaving for reasons related to a supervisor's bad behavior, to some kind of harassment, and that will be disclosed only on their way out the door. But that, just because they're leaving doesn't mean that situation shouldn't be investigated. Hotlines is a very common source. That can be challenging because hotlines are often anonymous, but nonetheless, in today's environment, even anonymous complaints in a hotline have to be taken seriously. Offhand comments, conversations overheard, are another source of information that potentially could trigger an investigation. And the final one listed here, social media. This is a little bit more dicey because we're talking about sometimes employee behavior that is outside of work, but it's broadcast on social media, and there's potential that it could have workplace consequences. And if it does, then that's something that may trigger an employer's obligation to investigate, or at least it would be prudent to investigate. So why should an employer investigate? Well, there's a lot of different reasons. One is if the information you have that triggers it is a potential legal claim, and sometimes you've never heard of it. So you have to evaluate what is this claim? Is there a basis for it? And what should we do about it at this point? A more practical, immediate reason too is to remedy misconduct, to discipline employees who engage in misconduct. Sometimes the only way to find out about that is through an investigation. The next one is along those lines, to prevent smaller problems from becoming bigger problems if nothing is done about them. Employee expectations is certainly not the only reason an investigation should occur, but it does play a role. Again, this is something that's in today's workplace environment, that policies often promise investigations of complaints, and employees have more of an expectation that if they bring something to management's attention or to human resources attention, that it's going to be looked into. Finally, and we kind of touched on this already, responding to a legal inquiry from an agency such as EEOC. And lastly, the establishment of legal defenses really used to be, that was the most important reason to investigate, and it still remains an important one. Perhaps not the most important anymore, but many of you probably know that if there's a claim of sexual harassment or other harassment based on protected activity, and it's by a co-employee, that if the employer takes prompt and effective action to remedy that situation, then it can avoid liability for the harassment. And an investigation is one way to learn of that conduct and take prompt action as a result. Also, there's in some legal cases, there's a defense of good faith. The FMLA is a good example. If an employer has a good faith belief that there's FMLA abuse going on, for example, even if in the end they're wrong, if they've substantiated that belief with an investigation, it holds a lot more weight in the legal case than if they don't have the facts resulting from the investigation. This next slide refers to policies concerning investigations. It's always a good idea to have a written policy that's published to the employees. What you say to the employees about when you're going to investigate can be very important. There are a lot of policies that I run across in my practice, and they tend to be policies that have been around for a while that state that any complaint will be immediately or promptly and thoroughly investigated. And that's certainly a good thing to do. But you have to be careful about making a promise like that in writing, because different situations warrant different types of investigation. And you have to be careful as an employer about over-promising what it is you're going to do. Certainly, the policy should be that you're going to investigate complaints, but it's a better idea to avoid characterizing how you're going to do it in your policy. It's important in a policy to tell the employees what are the consequences if they don't cooperate, and there should be consequences for employees who refuse to cooperate. And again, the next one, talking about not over-promising, you just have to be careful about using too many adjectives and adverbs to describe what action you intend to take. The policy should be that complaints are going to be investigated, and that's usually the best type of language to use. This next couple of slides summarizes what, in our view, would constitute a successful investigation. Now, we start with the scope of it. It's best for the investigator to have a clear scope of what it is they are supposed to do. What are the factual and or legal issues that they're supposed to investigate? Having an impartial and credible investigator is important in a successful outcome, especially a situation that might end in litigation. Prompt and reasonably thorough, and that term reasonably is deliberate, because whether an investigation is thorough is often in the eye of the beholder, and the investigation should fit the circumstances of the allegations and the people who are involved in the alleged conduct. A successful investigation should typically include interviews of witnesses, a review and analysis of relevant documents and data, and care should be taken to ensure that the documents and data are both gathered and preserved. Successful investigations, it's important that the people involved, that is the complainant, the subject of the investigation, and even witnesses, are protected during all phases of the investigation. That is, there's no retaliation. Confidential information is protected. And when we're talking about confidential information, we're not necessarily talking about information or facts that witnesses disclose during an interview, because often that can't be confidential. But we're talking about things like trade secrets, data, that kind of thing. Scope creep avoided. It's very common in an investigation when the investigator is interviewing witnesses and reviewing documents to come upon other issues that may or may not be related to the investigator's original mission. And sometimes going down those bunny trails is warranted, sometimes it isn't. The general rule is it's best for an investigator to keep the scope focused on what the original mission was. And we're going to talk about later in the presentation about situations where the opportunity to expand the scope occurs and how that should be addressed. It's important in a successful investigation for key individuals to be heard, the complainant, the subject, and other witnesses, and that the investigator give a thoughtful and balanced analysis. Finally, The results of the investigation should be communicated to the appropriate people and appropriate action taken as a result, depending on what the findings are, whether that be adverse employment action like discipline or termination, whether it means more training, whether it means reporting to third parties like law enforcement or other government agencies. You just want the appropriate steps to be taken at the conclusion. Marvin, any questions so far?
So far, we're good.
Okay, very good. So now the next part of the presentation is planning the investigation. What we're talking about here is, and we use sports analogies too much in my line of work, but what you're looking for before you actually start the investigation is having a game plan in place. And a game plan is something that should be flexible. Nonetheless, it should provide a path where the investigation is expected to go, what the investigator expects to do, and it's an opportunity to plan for potential obstacles that may come up during the investigation, unexpected things that may come up, and provides the investigator a roadmap for how to respond to those situations. So the first step, once a company decides to investigate, is who's going to be the investigator. And there are several things to consider when making that decision. This slide lists several of them. For example, the position of the subject. If the subject of the complaint is the CEO or a high-ranking executive, the company might choose a different investigator than they would if it was a lower-level employee at a remote location. The nature of the alleged conduct is important. If it's a sexual harassment complaint, that might warrant a different sort of response, a different investigator than might be some other kind of complaint that it might allege bad behavior or some policy violation, but it might not be a complaint based on protected activity or on a legally protected characteristic. If there's potential for litigation, that's going to play a role in who the investigator is going to be, and where that investigation report ultimately goes might play a role. If it's going to be seen by outside eyes, whether that's law enforcement, whether it's a regulatory agency, whether it's the company's insurance company, whether in the case of a public entity, if it's a city council or a school board, that's all going to play a role in who the investigator ought to be. Other important considerations include the person that is chosen to investigate. What is their relationship with the company? In some situations, it may be appropriate that the investigator is an employee of the company. It might be an HR person, could be an in-house lawyer. In other situations, it's more appropriate to go outside the company when choosing that investigator. Whether or not the investigator may ultimately end up as a witness, having to testify about their investigation and their findings and conclusions, is going to play a role. And the need and desire for privilege. And what we're talking about there is the attorney-client privilege. If privileged communications are an important aspect of the investigation or in directing the investigation, you have to have an attorney involved, whether that's in-house or outside counsel. And there's no guarantee if you have outside or inside counsel there will be a privilege, but it's certainly more likely if you have an attorney. If you don't have an attorney as your investigator, then there is no privilege at all. This slide contains a list of potential people to choose from. I said already, HR personnel in many cases are going to be perfectly suitable to investigate complaints or issues. It depends again on their role in the company, on the experience they have. A rule of thumb I always have is if the person to be investigated is at a higher level than HR, if they're an executive or a manager, it should be someone not in HR that does that. If it's more of a rank and file person that's being investigated, or the subject involves harassment at a plant or something like that, rank and file employees, HR might be the appropriate person. Inside counsel or outside counsel, both of those are suitable in the right situations. There are some other considerations when outside counsel is being considered. That is, if the lawyers that are being considered to investigate an issue are the same lawyers that the company usually uses for its defense counsel in legal claims, it might be better to use somebody else, because once that firm is retained to investigate something, the likelihood is it takes them out of the ability to defend that claim if a legal claim should arise. Another important consideration is, even if it's not defense counsel, if the lawyers in question are a law firm that the company typically uses or sends a lot of business their way, they may have relationships with certain people. The fact that it's an important client potentially could affect their view. We all have biases of certain things, and in situations like that, special counsel, a firm that's not your regular counsel, might be a better choice than using a lawyer from your regular law firm. Outside consultants are often good for investigations. There are private investigators, many former folks in law enforcement like FBI often consult and do employment investigations. They oftentimes have good experience and are suitable in the right situation. Depending on the nature of the employer, it might be helpful to have special expertise or special background. Law enforcement is the one identified here. Law enforcement is a field where there's a unique culture, there's jargon that's used. Having an investigator with a law enforcement background to investigate a complaint in a law enforcement agency is often helpful. Education is another setting where the culture of a school and the jargon used in the lingo, sometimes having a background in that particular business or industry, is very helpful. The next thing to think about when planning the investigation are interim measures. And what I'm referring to with interim measures are steps that should be taken from the time an investigation is commenced or the decision is made to investigate until the investigation is over. And so questions that the company needs to ask are, what harm could occur during this investigation if I don't take steps to remedy it? And the most obvious one, and I'm using again the example of a sexual harassment complaint, is how do you protect the complainant from further interactions with the alleged harasser? And what do you do with the alleged harasser? What do you do with these folks? So usually the question that we get is, okay, somebody needs to be put on a leave of absence. My default mode is that it's the subject of the investigation, the alleged harasser, that should be placed on leave before the complainant is placed on leave, unless the complainant happens to want to have time off. Putting someone on leave has the aura of being a form of punishment, and you want to avoid presenting that impression to a complainant that by making a complaint, now all of a sudden they're put on leave. That may be deemed some form of punishment or even some form of retaliation. And that might be viewed that way by the alleged harasser as well, but nonetheless, in weighing the potential harm, in my view, it's always better to put the harasser, alleged harasser, on leave rather than the complainant. The next common question is, if we're going to put them on leave, do we have to pay them while they're out? And my default mode is paid leave is always better than unpaid leave. Even in cases, and I see this fairly often, where the allegation alleges some pretty egregious behavior, and on the surface it seems like the evidence probably supports the truth of the allegations, and employers sometimes have a real problem with putting the subject on paid leave because they foresee in the end that this employee is going to be terminated, and why should we pay them in the meantime? But my advice nonetheless is, paid leave is better because if you're going to investigate, you need to go in with the idea you're looking for what the facts are. You don't prejudge the facts. And by placing it on paid leave, it presents that impression more of fairness than if it's unpaid. Notice to others. Again, it's not common that law enforcement would need to be notified, but there are situations where it does if there's evidence of a crime. Sometimes a company's insurer may need to be put on notice of certain things to make sure there's coverage. The next part of the planning stage relates to communications. How are you going to communicate with different people involved in the investigation? That includes the person who's complaining, the person accused of the misconduct, the witnesses who are going to be interviewed, and other employees who may not be interviewed, but they are going to be aware that an investigation is going on. Before you ever start down the road of investigating, it's good to have in mind what you're going to say to these various groups of people. How to make a record of the interview is something to consider before you ever start. Now, this slide deals with audio recordings. That's a common debate with investigators and lawyers. Is it better to record interviews or not record them? My general rule I've come to over the years is I favor no audio recordings of interviews rather than audio recordings. I'm not saying it should never be done, and there are others who have a different opinion, but audio recordings are not necessarily as reliable of a record of an interview as you would think it might be. People who aren't used to talking when they're being recorded, there's going to be nonverbal communication that doesn't get captured. There's talking over each other. The recording isn't always good as you might think it is. In fact, I kind of came to this conclusion. Our court system here in Iowa a few years ago, the Iowa Supreme Court decided to do away with court reporters during trials and just audio tape them. And it turned out that the record of the trial on audio tape was not nearly adequate for appeals purposes and other purposes as it was with the court reporter. And so they abandoned that, went back to the traditional court reporter. And that's what started leading me down the road that maybe audio isn't as good as you think it is. If witnesses or subjects know they're being recorded, sometimes it can have the effect of discouraging candor by them. In some states, it's legal to record an interview without telling the subject or the witness that they're being interviewed. In other states, you have to tell them. Regardless of what your state law is, if you record, I always think it's important to be upfront about that it's being recorded. And one of the disadvantages of that is it may inhibit the witness in some cases. And audio records can also be taken out of context. In litigation, it's easier to use them in a way that can be damaging than other records. So if you don't audio tape, you have to think what's going to be the record I'm going to make. Taking notes is the most common. Interviewers can take notes on a pad. They can use their computer to type if you're a good typer. Sometimes having a second person in the interview to take notes is helpful. Post-interview summaries, I think, are very useful. It's something that I do. My practice is to handwrite notes when I'm taking an interview and then do a post-interview summary immediately after that interview is done. And that's something that it's important to think about during the planning process, because when you're scheduling interviews, you want to leave enough time to do those post-interview summaries. And the reason I do it immediately after the interview is over is because it's obviously fresh in my mind at that point. There's information that I remember from the interview. It may not have been written in my notes, or it may not be fully expounded in my notes, but I can still, if I write or dictate a summary of it right after it's done, it can create an accurate record of what happened in that interview. A few other considerations in the planning process: obtaining documents, electronic evidence such as emails, text messages, photographs, and keeping a record of those documents where they came from is a good practice. Securing electronic communications, if that is relevant, such as text messages, computers, browsing history. This is much easier, of course, if the electronic devices where the evidence resides are owned by the employer. Then you have the right to access those devices and capture the evidence. If the employees are using their own mobile devices for texting, for example, it's a lot more limited, or at least the right of an employer to obtain that evidence in an investigation is much more limited. Typically, the employee would have to voluntarily turn that over for you to get access to it. It's important to think about at the beginning of the investigation about directing it. Who's going to direct it from the company's side? And that, what I mean by that is someone other than the person conducting the investigation. There should be someone who's the point person in the company. And the reason that's important, or at least a reason it's important, is because things come up during an investigation that were not anticipated at the beginning. You may discover that there's another person that you hadn't considered who has information. You may be alerted to additional conduct other than what was disclosed in the complaint that may be germane. You may learn about other victims of somebody who the complainant is complaining about. And the investigator should have someone available to consult with to make a judgment. Okay, is this something that we're going to pursue, or is this not something we're going to pursue? And when you're thinking about who that ought to be, this is where the privilege becomes very important, whether if you have an attorney as the investigator or if you have an attorney who's the point person, that certainly makes it more probable that the attorney-client privilege will apply, and those communications between the investigator and the attorney won't be later disclosed. Okay, this next slide just identifies some of the issues to think about in advance, where the witnesses are, what order are you going to do. It's a good idea, in my opinion, to have an outline of questions and topics that you're going to ask about, and that's not to limit what is going on, but or not to limit what you ask about, but at least to make sure that you ask the same set of questions initially to all the witnesses, so you have consistency. This slide talks about a couple of rights, Weingarten rights and Upjohn rights. If your organization, if the employees are have a union contract, that's what Weingarten rights are. Union employees have certain rights to have a union representative present in certain circumstances. And so it's important to plan ahead to determine whether the employer is going to permit that. In some cases, you have to permit it. And if you don't want that representative to be there, then you can't do the interview. Upjohn rights refers to the attorney-client privilege. There are certain situations where if the witness who's being interviewed is a manager or a high-ranking executive of the organization, in normal circumstances, they may expect the communications with the counsel to be subject to the attorney-client privilege. In an investigation, it's probably the investigator or ultimately the company is not going to want those communications shielded by the privilege, and so that witness has to be told in advance that this is an investigation, these communications are not privileged. It's a good idea to plan at least an outline of what you're going to say to everybody at the beginning of the interview, and how you're going to describe the investigation, so that's consistent in what you're telling different people. Again, these are just some kind of repeating some of these things, but to determine the scope of the investigation at the beginning, so you know if you're presented with an opportunity for mission creep, that you need to go back and consult with your person at the company to determine whether that's appropriate or not. Consider privilege to stay focused on the facts. This next slide refers to some challenges that it's important to think about in advance because they're not uncommon. One is, what if the employee wants somebody with them when they're interviewed, or maybe they'll demand that their attorney be present, or they refuse to give an interview. How are you going to respond to that? Now, I'm assuming for purposes of this discussion that we're talking about a non-union environment, and the general rule is, and there may be exceptions in some states, but the general rule is an employee is not entitled to have a representative present, nor are they entitled to have counsel present. And if they insist on that, on having somebody present, or they won't participate, you have to plan ahead. What are you going to do about that? Typically, we advise that that's deemed to be non-cooperative with the investigation, and has to be consequences for that. Similar with refusing to participate. How are you going to respond to that? What if, even though you as the investigator aren't going to record the interviews, what if the witness or the subject of the interview insists on recording? It's good to plan for that in advance as well. How are you going to discuss the recording with the witness, and what are you going to tell them about their rights to record or not? Language is sometimes a consideration if you have to interview people whose first language is not English. And then finally, just managing your emotions. It's not uncommon for investigators to be confronted with hostile, not necessarily hostile witnesses, but if perhaps the subject of the complaint, depending on what it is, can often be hostile or defensive, and you have to plan ahead to be in a position when it does happen so you can respond in an appropriate way. Okay, so that's the planning phase. Next, we move on to the execution phase. Marvin, do we have any questions at this point?
Yep, just going to say, I got one question here. It says, in the case of a whistleblower complaint that is investigated and determined to not have merit, what are your thoughts about then terminating this employee?
Terminating, as I understand the question, is whether to terminate the whistleblower. I'm assuming that's what they mean. If the allegations turn out not to be true, what do you do with the complaining person? Well, that's a delicate situation, because in many states, it depends, and sometimes under federal law, the act of whistleblowing or disclosing alleged misconduct is a protected activity. And the fact that the allegations turn out not to be correct or not to be true, that employee who's the whistleblower very likely is still protected from any kind of reprisal because of that. So now, if it turns out that the allegations are false, or especially if they're deliberately false, they made them up for the purpose of disruption or causing harm, maybe in that situation, some response should be considered. You certainly want to have good evidence that not only were they false, but it was intentionally false, and the person had a bad motive for bringing this up. But the fact that they turn out to be unfounded doesn't necessarily mean that the whistleblower didn't have a good faith belief that what they were presenting is true. So I think the general rule is, obviously the rule is you got to be really careful. Probably shouldn't take adverse action against a whistleblower unless you have good evidence of the presentation of intentionally false information. So that's a good question.
And the other question I have goes back to when you're talking about recordings. It asks, do you say that the person being investigated cannot record the interview themselves?
What I say is, for example, if the decision is made at the planning stage not to record, not to make an audio recording of the interview, then the goal is to have no audio recordings by anybody. So the procedure to follow in that situation is to, as part of your overview, your introduction to the witness or to the subject, you say that you're not recording the interview, and you want to try and do it in a disarming way, but sometimes a way to do that is say, are you recording this? And just ask them if they are. And if they say they are, then you ask them to turn off the recording device and not record it, because this is not going to be a recorded interview. And if they refuse, the decision has to be made or if they refuse to not record it, refuse to turn off the recording device, the decision has to be what are going to be the consequences of that? Is that going to be deemed a failure to cooperate with the investigation, which might result in consequences? So, those are, the decision could be made, okay, you can just live with it. I'm going to allow the employee to record it. I don't think that's the most desirable thing, because then they have control of it. The other aspect of that is with mobile devices having the ability to record, you may not know whether an employee or the witness is recording the interview. So that's why I think they should be asked, I'm not recording this, are you recording this? And if, regardless of their answer, if they say no, you say, okay, good, because in this investigation, we made a decision that we're not going to record the interviews. And of course, you can't control if they're doing it secretly, but then if that comes out later, that shows really a level of deception by them. So anyway, those are just some general ways that you can approach it.
All right. Well, that's all. Whoops.
Very good.
That's all the questions I have for right now.
Okay. Now our time is passing quickly, so we're going to go through the next phase fairly quickly. This is the execution phase, conducting the investigation. You've decided to investigate, you've planned it, decided who the investigator is going to be, where this is going to occur, who you're going to interview. Now what? First is the interviews, of course. That's the heart of what we're doing in an investigation. Basic things to think about is, where's it going to be? What kind of room is it going to be in? Am I going to be in a conference room where I sit across from the witness? Am I going to go to the witness's office and interview them there? Am I going to be able to be present and talk to the witnesses in person? That's a very important consideration when there are people who need to be interviewed who may be in a different location. They might be in a different plant. They might be in a different city or a different state. And so if they're not where you are, how are you going to interview them? By phone, by video conference, or are you going to go where they are or bring them where you are? Generally speaking, I think in-person interviews are very important in an investigation, because typically they require some kind of judgment of credibility. And it's credibility involves a lot of things, but part of it is looking at the person face to face. There's nonverbal cues, all kinds of things that you can discern in an in-person conversation that you can't discern by phone. So generally speaking, in-person interviews are better. If there's no way to do it otherwise, then phone interviews, you could probably live with them. When you're the interviewer, you want to be neutral. Of course, you want to be actually neutral, but you also want to portray to the witnesses you're talking to that you're open to hearing information from both sides. You haven't made any judgments yet. You want to be professional to everyone, being very respectful. You, of course, want to keep an open mind. As far as your technique in questioning, a good practice is to start with general open-ended questions with witnesses. Of course, you want to get their background, what they do with the company, how long they've been there, just so you get a sense of what they do. General questions like, do you ever have any problems with Joe in the plant? That's a very general thing that may elicit some things. If they say no, you may have to get some more specific. Well, have you ever seen any interactions between Joe and Barbara? Anything unusual there? So depending on how the answers are and what they disclose, you may have to get very specific. But again, you always want to start general, open-ended questions, let the witness talk, and then get down to specific questions later. It's always a good idea to take your time. How you interact with the witness is important. You want to appear that you understand, you recognize the legitimacy of what they're saying. You don't want to express shock or disappointment at allegations of misconduct. At the same time, you don't want to give the impression that you're taking one side or picking one side or the other. Of course, you want to get a clear story. Documents are sometimes important. It's always good to allow the witness to refer to documents if they have calendars, emails, whatever that would help them refresh their memory. You always want to give them access to that stuff because more information is always better. And you want to ask the witness to give you copies of whatever they're consulting with. Okay. These next couple slides just kind of go through questioning strategies. You want to, especially if you ask open-ended questions and if you get a talkative witness, it's a good idea to kind of go back and summarize what the witness told you so you can confirm you have an understanding. In many organizations or industries, there's jargon. You have to be sure that you have an understanding what the jargon means. If there's questions of time, place, relationships, it's a good idea even to have a witness draw things, okay, here's what the plant looks like, here's where I was standing, here's this machine. All those things can be helpful in creating a good record of your investigation so you have a good understanding of what actually happened. These are just some admonitions that it's important to talk to with witnesses. You don't want people going out and blabbing to others what you ask them, because the witnesses you talk to, you prefer they not know in advance what you're going to ask them. It's okay to tell the witness if they remember something later, that it's okay to get in touch with you to supply that. You will always want to be open to that. You might want to tell them that you may need to get in touch with them again to have a follow-up interview so they don't necessarily expect this will be the final time that they see you. This slide just lists some of the things you don't want to do. It can make people defensive, to question their motives or credibility to their face, to somehow blame them for something, to become preoccupied with doing other things, checking your email while you're interviewing them, or be so focused on your notes that you're not looking at them and engaging in an exchange with them. This last point, asking the outcome the witness expects, is a little bit of a delicate question. And I think it applies most of the time to a complainant, someone who made the complaint, because they probably have some expectation of what they want to occur. Now, there's a difference of opinion among investigators and lawyers whether you should ask what the complainant wants or what they expect to happen. I think many times they should be asked that question just to see what they say. Perhaps the complainant's expectation of what should happen may play a role in determining what actually happens. It's just good to have that information, and you have to be careful about taking it too much at face value. It's happened many times I've seen where, for example, the harassment investigation is a classic example where the person says, well, I don't want Joe to lose his job. I just want this behavior to stop. And so in the end, that's what happens. Joe doesn't lose his job. And then later the employee comes back and complains, and usually it's in a lawsuit. And part of their gripe is they still have to work with Joe, and the company didn't do anything in response to her complaints about it. So it's a delicate question whether to ask it. I tend to err on the side of asking a complainant what it is they expect, because I just want to know what they say about that. Just a few cautions about dealing with documents and whether they're accurate or not. Dated documents are always better than undated ones. Microsoft Word or other software, we all know, has an auto date function, so the date that appears on the document that's printed out may or may not be the date that it was created. Identifying handwriting and what it means sometimes can be important, and whether the person has selectively given you information rather than giving you everything is an important thing to consider. These next few slides just deal with kind of the reporter's aspect of investigating, asking all the questions about who, what, when, where things happened. We've touched on these things already: electronic evidence and interim measures. Additional considerations. This asks again what the complainant wants. We've discussed that already. Protecting the complainant is very important, and it's a good idea to talk to the complainant and really all witnesses in the investigation. It's important for the investigator to tell them that the company strictly prohibits any kind of retaliation because somebody made a complaint, because they participated in an interview, and if they think they have been subject to retaliation because of it, it's very important that they report it to HR or their supervisor immediately, or whoever the right person is. It's also important to talk to the accused about retaliation, to make sure that that person is informed that retaliation against the complainant in any form is not acceptable, and if it happens, there'll be consequences for it. This is a slide presents a situation. We kind of talked about it before, where the complainant doesn't want you to do anything bad to anybody because of it. In that situation, the approach is to do your best to make the person comfortable that what their complaint or what they said in the interview is not going to be the cause of what happens. It's because of everything that's revealed in the investigation, and that management has to make a decision based on a thorough investigation. You don't want some complainant having guilt or feeling guilty because something bad happens as a result of coming forward. Again, these are things to consider when telling witnesses, complainants, subject to the investigation, how much detail to give them about what's been complained about. With witnesses, you have to be a little more careful. They're not necessarily entitled to all the details of what's been alleged. If it's the subject of the investigation, then they probably are entitled to know the details so they can respond adequately. These are some subjects we've talked about before: getting the documents, preserving electronic evidence, ensuring that there's no retaliation and telling the witnesses about that, and confidentiality. Now, these interview strategies, we've touched on this before in the preparation, but that is, you want to plan in advance, of course, how you're going to record the interview, how you're going to make the record. And then in the execution phase, you got to try and do your best to carry that out. There are situations that happen where if your plan is to take written notes and then do a memo summary right after the interview, sometimes schedule things happen, you're not able to do it, and you may have to change course, you may have to do your memo some other time, but as best you can, you want to stick with the strategy you picked at the beginning as far as making the investigation record. Now, I want to skip ahead a few of these slides. We're getting to the end of our time, and I want to talk about what to do when the investigation is over for a few minutes. Marvin, do we have any questions from that last
I've got
stage?
two questions for you. One was kind of as you were switching over. It says, you speak of consequences. Can an example be provided as to what a consequence would be if the interviewee refuses to comply? For example, refuses to turn off the recording device.
Right. Then, I mean, again, that's something to think about in advance, but if it's an employee and they are charged with cooperating with the investigation, then if they don't cooperate, then you can stop the interview and the employee is going to be subject to discipline, up to and including termination. I mean, that's just an example. Again, it depends upon how serious. You have to make a judgment at the beginning about, okay, if there's going to be no recordings, are you really, how firm do you want to be with that, and weigh that against the importance of getting the witness's statement. So, but generally speaking, that would be whatever consequences, whatever discipline or something might result from other types of misconduct, then that's the sort of discipline that can be imposed for refusing to cooperate in an investigation.
Okay. And the other question I have here came recently, says for compliance reasons, when the same three people do all the investigations within an agency, should investigations be reviewed or audited periodically to make sure that policy and procedures are being applied fairly and across the board?
Yeah, this sounds like a situation where we have, these are employees of the company and maybe in a compliance area that investigate perhaps certain types of complaints. Yeah, I think that's a good idea to audit that periodically to make sure that everyone doing an investigation is following the same practices and procedures. In practice, it could be that the practices and procedures are outlined, and in theory, they're all following them, but to look at the outcome investigations, see if they're following similar procedures, see if their work product is consistent with the policy. That's a good idea to do that periodically. Okay, those are good questions. We've got about 4.5 minutes left, so I'm going to speed through just to try and catch some highlights of this last part. First of all, so you've done the investigation, you've gotten all the documents, you've done the analysis. Now, what do I do now? Many times the answer is, well, you're going to write a report or give some kind of report. The first thing you do is did I get everything that I needed? There's many times when you're actually sitting down to do the analysis of what you have and communicating in a report, and you realize that there was somebody you didn't talk to who may have an answer that you need, or there may be a question that you need an answer to and you didn't ask, or there might be a document that you don't need. So, and that's not uncommon. In that situation, it's important to go back and tie up those loose ends. If you need to talk to a witness again, talk to them again. If you need that additional document, get that additional document. It's really important that you want your work product to be based on the facts and not avoid any kind of speculation about what you think might be out there. Okay, this slide refers to, did your investigation from beginning to end follow what you thought it would be at the beginning? And oftentimes it doesn't, but if it doesn't, then it's a good idea to make some kind of record about why it was that the scope of the investigation changed, what new information came about, etc. So if you're asked about it a year or two later, you have a record that you can explain to somebody why you made that change. This slide we've touched on that already. What if you're missing information? You need more answers. It's important to go close up those loose ends. Okay, documentation is the next one. Completing your investigation file. You want something to be organized. You want to have all your investigation notes and memos, summaries, all the documents you received as part of the investigation. You want to identify the source of those documents and where you got them. And then when you're considering a report, which is the deliverable in the end of an investigation, it's very important to think about who's going to get this report. And different situations will be different people. Sometimes it'll just be internally in the company, people who have to make a decision about discipline or discharge. But even in those situations, if it involves an adverse employment action that could lead to legal action in the end, there's going to be people who see that investigation like a judge or a jury, lawyers that are going to ask questions about it. And so you have to consider that in what you put in your investigation report and how you make a record of your investigation. In some situations, for example, with public entities like municipalities or school districts, if it's possible, then an investigation might be a public record, and it might be shown to a public official, city council, something like that. And you have to think about your investigation being reported on in the media. So when you're preparing it, you have to think about those audiences. Making a credibility determination. This is something that is very common in many investigations. And ultimately, there are a few situations where you're going to have he said, she said, the so-called he said, she said situation, where you have one person saying one thing, another thing that contradict, and there's no other witnesses. Okay. Even in those cases, if you can make a credibility determination, it's a good idea to do so. And credibility is more than just a subjective judgment about, okay, did I believe what they say? Look at their body language. It's important to consider people's motives, the opportunity, where they were, is what they said consistent with documentation? Does it comport with common sense? But regardless, in most situations, you're probably going to have to make a determination that somebody is accurate and somebody is not. Okay. Many investigations, you're asked to make a judgment about whether the conduct that you found, the factual findings, what are the consequences of that? Is it some kind of legal violation? Did it violate the policy? Does it just tell you that there are maybe training needs to be done, that there has to be discipline? So taking the facts that you learned and analyzing them to determine what the consequences are is often part of your charge. Again, reporting is a big part of it, whether to have a written report or not a written report. Most investigations I'm involved in, the client wants a written report, but that's not always the case. Sometimes they just want it verbal, and that is appropriate in some situations. Sometimes the client wants recommendations. Okay, I want to know what the facts are that you found, and I want to know whether they violated policies, but what do you say ought to happen in this situation? And that's certainly a legitimate thing to ask of an investigator. You may need more information about how other situations were treated, what mitigating circumstances are, and what all the range of options are. Communication, we discussed that briefly already. To whom will this investigation go? Who are you going to communicate with about it? Notifying the people involved, the stakeholders of the outcome of the investigation, in my view, is important. You want to tell the complainant the investigation is complete. Typically, you cannot always tell them what the consequences are as far as discipline, that sort of thing. Sometimes it's obvious if it results in a termination of the subject of the investigation, but you want to communicate mostly in writing. The investigation's over. Thank them for coming forward with the information. If you can't really tell them the details, you have to tell them that in the writing and communicate to them that any further retaliation is prohibited. It's never a bad idea to think about communicating with the witnesses that were talked to in the investigation and maybe other employees. Simply a statement that the investigation is over. It's a confidential personnel matter, but thank you for your cooperation. Finally, in making recommendations about action, the advice of measuring twice, cut once, the old carpenter's adage is always good advice. And last but not least, follow-ups to the investigation in the future. Retaliation sometimes happens well after an investigation and action is over. It's never a bad idea to follow up with supervisors, witnesses, complainants, to make sure everything's going okay, ask them whether there's been any retaliation, and document what was done. And finally, the postmortem on the investigation, if you have time, is always a good thing. What did I do wrong? What did I do right? What could I do better next time? So I think we've run out of time, Marvin. I appreciate very much your attention. And
do you have time for one more question?
I have time for one more question, and folks should feel free to email me offline if they want to too, and I'll do my best to answer.
Okay. It says here, if an employee who has a complaint against a supervisor in the past rendering non-conclusive results, he said, she said, comes to you later and says there's no change, it's hostile because the supervisor doesn't speak to me, the supervisor will be talking to other employees but ignores the complainant, does a follow-up investigation need to be implemented?
Yeah, that's a good question. That's a dicey one because now we're talking about retaliation as a result of making the complaint. And in today's environment, my advice is that an investigation ought to be done. Now, whether that's the same level and scope as the original investigation, it doesn't necessarily have to be. But if an employee complains about conduct that could be retaliatory, it should be investigated in some form.
Patrick's email address, psmith@fredlaw.com. Once again, I am Marvin at hrsimple.com. And I want to thank you, Patrick, for taking the time to do this for us. We appreciate it very much.
Thank you. It's my pleasure.
And we thank all of you for being here. And we will be back next month with a new webinar from HR Simple. Everybody have a great day out there. Bye-bye.